POV. Your friend has a problem with his Islamic bank.
Guys, I'm seriously stressed right now.
Why? What happened?
My Islamic bank rejected my business restructuring plan. I already explained my financial status, but somehow they still refuse it.
So, what are you going to do now? Sue the bank?
That's the problem. Going to the court can be complicated and also expensive. Plus, the court proceeding can even take years. Your business might collapse even the case end.
Actually, there is another way. We can use alternative dispute resolution, which is also called as ADR.
What is ADR? I have never heard it before.
Solving disputes without going through full court proceedings, like mediation, arbitration, negotiation, and also the financial advice system.
So wait. I can solve the case and my problem without even going to the court.
Exactly. And it's also faster, cheaper, more private, and also more suitable for Islamic banking and financial. And it's also values the Islamic values too. Justice, fairness, peace, and also mutual respect.
Oh, that sounds so better.
Let's go to the full details.
Hello everyone, y'all must be wondering, how does ADR actually works? Now, we will break it to you. Alternative dispute resolution, or ADR, refers to methods of resolving disputes outside the traditional court system. So, instead of relying fully on court proceedings, ADR encourages parties to settle dispute through discussion, negotiation, and mutual agreement. In Islamic banking, ADR is important because disputes involve not only legal rights, but also ethical and Sharia principles. Islamic finance promotes justice, fairness, cooperation, and peaceful settlement. Therefore, ADR is considered more suitable because it focuses on harmony rather than confrontation. There are several types of ADR, such as mediation, arbitration, ombudsman, and negotiations. So, ADR is important because it saves time, cheaper, protects confidentiality, and preserves business relationships. Most importantly, ADR reflects Islamic values such as justice, fairness, cooperation, and mutual respect.
So why ADR is important? Let me explain one by one. Firstly, we have mediation. Mediation involves a neutral third party called a mediator who helps both parties communicate and reach for agreement. The mediator does not make decisions but only facilitates discussion. The second type is arbitration. Arbitration is more formal because an arbitrator listens to both sides and gives a binding decision. Next is the ombudsman, such as the Financial Ombudsman Scheme or FOS. The ombudsman investigates complaints and helps customers resolve disputes with financial institutions fairly and at low cost. Lastly, negotiation is the simplest form of ADR where both parties directly discuss the issue and they try to reach for a mutual agreement. ADR is very important in Islamic banking because it supports the objective of Islamic law or maqasid Sharia such as justice, honesty, and also cooperation. Unlike litigation, ADR promotes peaceful settlement while maintaining trust and long-term relationship between banks and also the customers.
Guys, why do we need to resort to ADR? Is there any problem with traditional litigation? As the Islamic banking industry expands, disputes between customers and financial institutions have also increased. Common disputes including unfair treatment, payment issues, and contractual misunderstanding. Many people assume that court litigation is the only solution. However, litigation often creates more problems. Firstly, court proceedings are expensive and time-consuming. Some cases may take years before reaching a final judgment, causing financial stress and also business delays. Secondly, litigation may damage relationships between both parties. This is especially harmful in family businesses or partnership because long court battles create tension and conflict. Islam encourages peaceful settlement and discourage unnecessary hostility. Thirdly, court proceedings are public. Sensitive financial information and business weaknesses may become exposed to the public, affecting reputation and customer confidence. Therefore, ADR offers a better solution because it is faster, cheaper, private, and less confrontational.
Our claim is not just by saying, it is proven. I will now explain the research methodology and the finding we got. The study adopted a doctrine, legal research methodology. This means the research is based on the legal statute, cases, and legal analysis, and also legal journals as well. Our primary sources include the Islamic Finance Service Act 2019, the Arbitration Act 2005, and Malaysian Islamic banking cases as well. Secondary sources include journals, academic writings related to ADR and Islamic finance. One major finding is that ADR provides flexibility and customized dispute resolution mechanism. Unlike court litigation, ADR allows parties to choose mediator or arbitrator and appoint experts in finance, Islamic finance, and determine the procedure suits for both parties. The flexibility is important because sometimes the expert in Islamic commercial law or muamalat ADR also have the confidentiality and preserve the business relationship as well.
Is it true that ADR protect confidentiality? Yes, one of the major of ADR is confidentiality. Unlike the court proceeding, ADR discussions are conducted privately. For example, in the case of Malayan Banking Berhad against Ho Marilyn Siot Lin, public court proceeding exposed witnesses in banking documentation and procedures that affected the bank public image and also customers' confidence. ADR helps avoid such reputational damage because sensitive information remains private. Now, regarding the ADR route for a business owner whose restructuring plan was rejected by the Islamic Bank. The first step is referring to the Dispute of Financial Ombudsman Scheme or FOS. At this stage, mediation and negotiation are encouraged based on the Islamic concept of suluh, meaning peaceful settlement. If mediation fails, the case proceeds to adjudication under FOS framework, where the Ombudsman reviews the dispute and gives a fair decision. If the dispute still remains unresolved, the final step is arbitration under Arbitration Act 2005. Arbitration allows experts in Islamic finance and Sharia principles to resolve disputes professionally and privately.
All I would say is ADR is so relevant. ADR is highly relevant in Islamic finance because it aligns with Islamic legal principles, and arbitration itself originates from the Islamic concept of tahkim, which refers to dispute resolution through an independent third party. Several Malaysian cases demonstrate the limitations of litigation in Islamic banking disputes, and those cases shows that civil courts sometimes face difficulties in fully understanding the Sharia principle in Islamic finance dispute. Therefore, ADR become a more suitable solution because disputes can be handled by experts in Islamic finance. In conclusion, ADR plays a crucial role in Islamic banking because it is faster, cheaper, more flexible, and more confidential than litigation. The Financial Ombudsman Scheme and arbitration provide effective and Sharia-compliant dispute resolution mechanisms while preserving the relationship between the parties. Therefore, parties involved in Islamic banking disputes should prioritize ADR before resorting to the court proceedings.
So Nafis, do you know what is ADR now?
Yes, now I understand that ADR is a better way to solve dispute without going through a long and stressful court trial.
We hope this explanation helped you out there.
Bye!